The tension in the Supreme Court chamber was palpable as Congresswoman Jasmine Crockett stood at the podium, facing the nine most powerful judges in America. She was defending a voting rights case that could affect millions when something shocking happened. Chief Justice John Roberts laughed dismissively in the middle of her argument about discriminatory voting laws. "Congresswoman, with all due respect," Roberts smirked, "the court has heard these same arguments for decades. The data simply doesn't support your position." The courtroom fell silent. Had the Chief Justice just mocked a sitting member of Congress? What happened next left everyone speechless. In just 3 minutes, Crockett delivered a response so powerful and backed by irrefutable evidence that Roberts would be forced to reconsider the case. This is the incredible true story of how a freshman congresswoman stood up to the most powerful judge in America and won. Before diving deeper into this extraordinary Supreme Court showdown, let's understand who Jasmine Crockett is. Born in St. Louis, Missouri, she grew up valuing education and hard work. Her parents instilled in her a deep respect for public service, standing up for what's right. After earning her law degree from the University of Houston, Crockett built a reputation as a fearless civil rights attorney, taking on difficult cases involving police brutality and voting rights violations. While others sought high-paying corporate clients, she chose to represent ordinary people fighting against powerful institutions. "Justice shouldn't depend on the size of your wallet," she often said. Her legal work led her to politics, where she served in the Texas House of Representatives before being elected to Congress. Even as a freshman, she distinguished herself with her sharp legal mind and commitment to constitutional principles. Unlike many politicians who viewed voting rights as abstract concepts, Crockett had represented actual voters who had been disenfranchised. The case that brought her to the Supreme Court was Jefferson County versus United States, a landmark voting rights case. At issue was a new law requiring voters to present specific types of government-issued photo ID, reducing early voting days and eliminating Sunday voting, important for Black communities. Supporters claimed it was necessary to prevent voter fraud. Opponents argued it was a thinly veiled attempt to suppress minority votes. The case had worked its way through lower courts before reaching the Supreme Court. While Crockett wasn't directly litigating, she was invited to present an amicus brief, given her expertise in voting rights. For her, this was the culmination of years of fighting for voting rights, with implications that would set precedents nationwide. The Supreme Court chamber was packed on that fateful morning. Civil rights leaders, legal scholars, and journalists filled the gallery. As the most junior member of Congress to present an argument before the Supreme Court, Crockett felt the weight of history on her shoulders. She knew the conservative-leaning court had been skeptical of voting rights claims, having weakened the Voting Rights Act in previous decisions. But she was prepared, having spent weeks researching and practicing her arguments. "Mr. Chief Justice, and may it please the court," she began, "I appear today to address the constitutional implications of Jefferson County's voting legislation." Her presentation was precise, outlining how the ID requirements created disparate impacts on minority communities. The justices listened attentively, occasionally asking questions that Crockett handled with ease. However, when she began discussing the historical context of voting restrictions, Roberts's demeanor changed. "Congresswoman," he interrupted, "are you seriously suggesting that requiring an ID to vote is comparable to Jim Crow laws?" His tone was dismissive. Before she could respond, he continued, "This court has repeatedly held that states have legitimate interests in maintaining the integrity of their elections." As Crockett cited specific evidence of discriminatory impact, Roberts chuckled and shook his head. "Congresswoman, with all due respect, the court has heard these same arguments for decades. The data simply doesn't support your position." A murmur ran through the courtroom. Had the Chief Justice just laughed at a substantive argument? Crockett paused, taking a deep breath. In that moment, she decided to abandon her notes and speak directly to the fundamental issues at stake. "Mr. Chief Justice," she said, her voice steady, "I must strongly disagree." What followed became one of the most remarkable exchanges in Supreme Court history. The courtroom fell silent after Roberts's laugh. Justice Sotomayor glanced at him with disapproval. For Crockett, this was a moment of truth. Every civil rights attorney faces dismissive judges, but having the Chief Justice laugh at evidence of voter suppression was extraordinary. Crockett could have retreated to safer arguments. Instead, she chose to confront the disrespect she had witnessed. Mr. Chief Justice, when presented with evidence of American citizens being denied their constitutional right to vote, laughter is never an appropriate response, especially from the highest court in our land. An audible gasp swept through the courtroom. Attorneys rarely challenge a Supreme Court justice's behavior during oral arguments. Roberts' face flushed slightly. Congresswoman, I was not laughing at voter disenfranchisement. I was reacting to the suggestion that these ID laws are comparable to historical voting restrictions. Crockett stood her ground. With respect, Mr. Chief Justice, that distinction offers little comfort to the citizens being denied their right to vote today. The evidence I'm about to present will demonstrate why these modern restrictions deserve to be taken just as seriously as historical ones. What might have been a momentary tension developed into a direct confrontation. Roberts' expression hardened. Congresswoman, this court makes decisions based on constitutional interpretation, not emotional appeals. If you have specific evidence rather than general assertions, the court would be interested in hearing it. But Crockett had not come to play it safe. I have precisely such evidence, Mr. Chief Justice, she replied. With the court's permission, I would like to present it in detail. Crockett began methodically laying out the evidence that Roberts had dismissed. She presented data showing how voter turnout among minority communities had dropped significantly after the ID requirements. In Jefferson County, voter participation among black voters decreased by 27%, while white voter participation decreased by only 3%. She then addressed the purging of voter rolls. Over 50,000 registered voters were removed in the months before the election. Analysis showed that voters in predominantly minority precincts were 4.3 times more likely to be purged than those in predominantly white precincts. Justice Thomas interjected, "Correlation does not prove causation, Congresswoman. Couldn't these disparities be explained by other factors?" It was a fair question, and Crockett was prepared for it. Justice Thomas, that would be reasonable if we didn't have direct evidence of intent, but we do. She presented internal emails from the Jefferson County Election Board discussing ways to minimize turnout in problematic voting precincts. Crockett revealed a statistical analysis from the Civil Rights Division of the Justice Department showing that even controlling for variables like income and education, the impact of these voting restrictions remains statistically significant at the 99% confidence level. The justices were now paying close attention. Even Roberts had stopped looking dismissive. But the most dramatic moment was yet to come. As Crockett continued presenting evidence, Roberts pushed back more forcefully. Congresswoman, even if we accept your statistical evidence, the Constitution does not guarantee that every voting procedure will impact all communities identically. States have legitimate interests in preventing fraud. It was a standard argument conservative justices had used to uphold voting hour, but Crockett was ready. Mr. Chief Justice, I anticipated this concern, which is why I've also analyzed the fraud prevention justification. She produced another document. This report details every credible allegation of in-person voter fraud in Jefferson County over the past 20 years. The total number is 14 cases out of more than 1.5 million votes cast. She paused to let that sink in. 14 cases? For this, we're willing to create barriers that demonstrably prevent thousands of legitimate voters from casting their ballots? Roberts remained unmoved. The prevention of even a small amount of fraud helps maintain public confidence in elections. Mr. Chief Justice, Crockett said, her voice carrying a hint of indignation, I find it troubling that this court seems more concerned with theoretical fraud than with actual documented disenfranchisement happening right now to real American citizens. Justice Alito, one of the court's most conservative members, bristled. Congresswoman, are you suggesting this court is indifferent to voting rights? The question hung in the air. The entire courtroom held its breath. This was a critical moment for Crockett. She had directly challenged the court's commitment to fundamental rights and now faced hostility from multiple justices. Had her confrontational approach destroyed any chance of a favorable ruling? Crockett paused, knowing her next words could determine the outcome of the case.
Justice Alito, I am suggesting that this court's recent jurisprudence has prioritized hypothetical concerns about fraud over documented evidence of disenfranchisement, and I believe that history will judge this prioritization harshly. She then reached into her briefcase and pulled out her final piece of evidence. Before the court dismisses the severity of modern voting restrictions, I would like to submit this final document into the record. She removed a bound folder labeled Comparative Analysis, Voter Suppression Techniques 1890 to 2025. Mr. Chief Justice and members of the court, Crockett began, I believe there has been a fundamental misunderstanding about the nature of modern voter suppression that has colored this court's jurisprudence on voting rights. She opened the folder, revealing meticulously organized sections. What I have here is a comprehensive analysis comparing historical voting restrictions with their modern counterparts. This isn't about emotional appeals. It's about recognizing patterns that might not be obvious at first glance. The justices leaned forward, intrigued. Even Roberts seemed curious about this new approach. The first section examines the poll taxes of the Jim Crow era alongside the economic burdens created by modern ID requirements. Our research shows that obtaining the required ID in Jefferson County costs the average affected citizen $87 when accounting for fees and lost wages. For many citizens living paycheck to paycheck, this constitutes a significant financial burden. Moreover, she continued, just as literacy tests were administered unevenly to create discriminatory outcomes, we have documented systematic differences in how ID requirements are enforced across different precincts. She presented affidavits from voters in predominantly minority precincts who had been turned away despite presenting the same types of ID accepted in predominantly white precincts. This isn't about the abstract text of the law, Crockett emphasized. It's about how these laws function in practice. Justice Barrett, who had been quiet until now, spoke up. Congresswoman, this is interesting data, but how do you respond to the argument that voting procedures have always evolved over time and some degree of burden on voters is inevitable? Justice Barrett, that's an excellent question. The burden itself isn't the only issue. It's whether that burden is distributed equally among citizens. She presented a statistical analysis showing how the burdens created by Jefferson County's voting restrictions fell disproportionately on certain communities. When 72% of the burden falls on communities that represent only 27% of the population, we must ask whether this is simply an inevitable evolution of voting procedures or something more troubling. The most powerful part of Crockett's presentation was yet to come. She turned to the final section of her document labeled Legislative Intent, the Public Record versus Private Communications. Throughout this case, county officials maintained that these voting restrictions were implemented solely to protect election integrity. But this final section contains evidence that tells a different story. She produced transcripts of county commission meetings and email exchanges between election officials. In an email dated March 15, 2024, the county election commissioner wrote, "The beauty of these ID requirements is that they look neutral on paper, but we all know who's going to have trouble meeting them." Murmurs spread through the courtroom. Crockett continued, turning to another document. In this text message exchange between county officials after early voting was eliminated on Sundays, an official writes, "No more souls to the polls. Problem solved." The evidence was damning. These weren't theoretical arguments. They were proof of discriminatory intent. Chief Justice Roberts, who had laughed earlier, now looked troubled. "Congresswoman Crockett," he said, "why wasn't this evidence highlighted in the lower court proceedings?" "Mr. Chief Justice, some of this evidence was presented in the district court, but its significance was downplayed. Other pieces, particularly the text messages, only came to light during additional discovery." She paused, then delivered her most powerful point. "This evidence has always been there for those willing to look. The patterns of who is affected by these laws, the minute number of actual fraud cases compared to the thousands disenfranchised. What's been missing isn't the evidence, but the willingness to recognize what this evidence clearly shows." It was a remarkable moment, a direct challenge to the court to confront the reality of voter suppression. Justice Sotomayor, a consistent advocate for voting rights, built on Crockett's point. "Counsel for the county, how do you respond to these statements from county officials that indicate discriminatory intent?" The county's attorney approached the podium, looking shaken. "Your Honor, those statements, if authentic, do not represent the county's official position." "But they do represent the actual motivations behind these laws," Crockett interjected. "Under this court's own precedents, evidence of discriminatory intent is crucial to equal protection analysis." Roberts nodded, acknowledging the established legal principle. The mood in the courtroom shifted dramatically. What had begun as an uphill battle had transformed into a moment of reckoning. The justices who had been dismissive were now engaged. As Crockett concluded her presentation, she returned to the fundamental principles at stake. The right to vote is not just another legal issue. It is the foundation upon which all other rights in our democracy rest. When we allow that right to be undermined through technically neutral but practically discriminatory measures, we betray the promise of equal citizenship that the 14th and 15th Amendments guarantee. She looked directly at Chief Justice Roberts. "Mr. Chief Justice, you once wrote that the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. I respectfully suggest that the way to stop discrimination in voting is to recognize it when it occurs, even when it comes dressed in the modern garb of election security." The reference to Roberts's own words brought a hush over the courtroom. "Thank you, Congresswoman," he said, his tone now respectful. "You've given this court much to consider." As Crockett returned to her seat, legal observers exchanged astonished glances. In 30 minutes, she had transformed the case from a likely defeat into a potential landmark victory for voting rights. In the hours following the hearing, legal experts scrambled to make sense of what they had witnessed. CNN's Jeffrey Toobin called it one of the most remarkable turnarounds in Supreme Court history. Fox News's Shannon Bream noted that, regardless of where you stand on the issue, Crockett's presentation was a masterclass in constitutional advocacy. On the courthouse steps, civil rights leaders who had been pessimistic about the case's prospects now expressed cautious optimism. Reverend William Barber II told reporters, Today, we saw what happens when truth confronts power directly. Crockett was more measured in her public comments. This isn't about me or any individual victory. This is about whether our Constitution's guarantees apply equally to all Americans, regardless of race, income, or zip code. Behind the scenes, the impact of the hearing was even more dramatic. The justices held an unusually long conference following the arguments, reportedly lasting over 3 hours, with Roberts leading an in-depth discussion about the evidence Crockett had presented. 2 weeks later, the court ordered additional briefing on specific aspects of Jefferson County's voting procedures, a sign that some justices were reconsidering their initial positions based on Crockett's arguments. 3 months after the hearing, the Supreme Court issued its ruling in Jefferson County versus United States. In a surprising 6-3 decision, the court struck down key provisions of Jefferson County's voting law. The majority opinion, authored by Roberts, reflected how profoundly Crockett's presentation had affected the court's analysis. While this court has previously emphasized that not every voting regulation imposing a burden on voters is subject to strict scrutiny, Roberts wrote, we cannot ignore substantial evidence that certain provisions were designed to disproportionately burden the right to vote of citizens based on race. In a passage that stunned legal observers, Roberts continued, the court acknowledges that our voting rights jurisprudence must evolve to recognize that voter suppression, like many forms of discrimination, adapts to legal constraints while maintaining its essential character. When presented with clear evidence that facially neutral provisions are being implemented in discriminatory ways, this court cannot and will not look away. The decision established a new framework for evaluating voting restrictions, requiring lower courts to conduct rigorous, factual inquiries into both the effects of voting laws and the context in which they were enacted. Justice Sotomayor wrote a concurring opinion praising the evidence Crockett had presented. Today's decision demonstrates the vital importance of bringing concrete, specific evidence of discriminatory impact and intent before this court. Legal scholars recognized the significance of the ruling. Professor Richard Hasen of UCLA Law School called it the most important voting rights decision in a generation. Harvard Law professor Lawrence Tribe observed that Roberts's opinion represents a significant evolution in his thinking about voting rights and race.
The broader impact of the case extended far beyond Jefferson County. Within weeks, voting rights organizations filed challenges to similar laws in multiple states, citing the new Supreme Court precedent. State legislatures reconsidered their approaches, and Congress introduced the Equal Access to Voting Act, establishing minimum federal standards for early voting, ID requirements, and voter roll maintenance. For Crockett, the case transformed her from a freshman Congresswoman to a nationally recognized civil rights leader. Law schools invited her to lecture on constitutional advocacy, and civil rights organizations sought her counsel on litigation strategy. Most importantly, the decision had real-world impacts. In the following election, voter participation in Jefferson County increased by 18%, with significant increases in previously underrepresented communities. An elderly voter named Margaret Wilson, who had been turned away from the polls for years, told a local reporter, "Today I felt like a full citizen again. I felt seen." 1 year after the landmark decision, Crockett addressed students at Howard University School of Law, reflecting on her confrontation with Chief Justice Roberts. What happened that day in the Supreme Court wasn't just about voting rights, it was about the willingness to speak truth to power, even when that power responds with dismissal. A student asked if she had been intimidated facing the Chief Justice, especially after he laughed at her arguments. Of course I was intimidated, Crockett admitted. The Supreme Court is an intimidating place. When the Chief Justice laughs at your argument, that's about as dismissive as it gets. She continued, but I remembered something my mother taught me. Jasmine, your truth doesn't become less true just because someone powerful doesn't want to hear it. Another student asked what lesson future lawyers should take from her experience. Preparation is essential, Crockett responded. I changed the Chief Justice's mind not through eloquence, but because I had the evidence meticulously gathered and powerfully presented. She added, but there's a deeper lesson too. Our legal system is designed to recognize that human institutions can make mistakes. When you believe in the Constitution and have the evidence to support your position, never be afraid to stand your ground, even against the highest authorities. The confrontation between Congresswoman Crockett and Chief Justice Roberts teaches us something profound about American democracy. It works best when we have the courage to challenge authority with facts and principles. Throughout history, progress has depended on individuals willing to speak uncomfortable truths to those in power. Crockett's confrontation with Roberts was remarkable not just for the challenge itself, but for how she presented meticulously researched evidence grounded in constitutional principles. She demonstrated profound respect for the Supreme Court while challenging its assumptions about voting rights. True respect for our institutions sometimes requires us to challenge them to live up to their highest purposes. For ordinary citizens, the lesson is powerful. Democracy doesn't work automatically. It requires active participation and the willingness to challenge powerful institutions when they fall short of constitutional principles. The right to vote is the foundation upon which all other rights rest. When that right is undermined, the entire democratic project is threatened. Crockett's willingness to defend that right reminds us of our responsibilities as citizens. As Martin Luther King Jr. observed, the arc of the moral universe is long, but it bends toward justice. It bends because people like Jasmine Crockett put their hands on it and pull. In that sense, Crockett's confrontation with Roberts isn't just about one case. It's about the ongoing process of making America live up to its founding promises, a process that requires courage, persistence, and an unwavering commitment to constitutional principles. If you've been inspired by this remarkable story of speaking truth to power, don't forget to like this video and subscribe to our channel. We bring you stories of American heroes defending our constitutional rights that you won't see in the mainstream media. Hit that notification bell so you never miss our latest videos about brave Americans standing up for justice and democracy. Remember, in America, the power ultimately belongs to the people, but only when we have the courage to claim it.